Hello and welcome to the BLC Box. My name is Steve Terrett and I'm delighted to be joined in the box today by Melissa Stock. Melissa is a barrister and she practices law from Normanton Chambers in London. She specialises in information law, in privacy, data protection, GDPR and human rights. She's a certified information privacy professional in European data law. And Melissa has recently written a book about the right to be forgotten, which it's an excellent book designed for everyone, really. Legal practitioners who are working in this area of law, privacy practitioners, data protection officers, organizations that handle data and who doesn't. And anyone who's interested in that area of law of data protection and personal information. So I think it's fair to say that all of us are involved in those areas of law, either as the giver of the information about ourselves or as someone who's processing data, either ourselves or within a company. So I highly recommend the book. And Melissa has very kindly agreed with her publisher to arrange a special discount for British Law Centre students and for those watching the BLC Box. I'll say more about that at the end. Melissa has her own blog, which is amazing. And it deals with all aspects of privacy and data protection law, and it's regularly updated. So literally you can keep on top of things as they're happening. It's www.privacylawbarrister.com. And I highly recommend that you check out blog there and the podcasts that are on there because they really, really are excellent. Now, that of course means that Melissa has experience not just in sitting in the interviewee chair, but in sitting in the interviewer chair, in my chair as I'm sitting in today. So that makes me doubly nervous about doing this interview. But thankfully, I've had the pleasure of meeting Melissa before, and she has done everything to calm my nerves by generally being a lovely, friendly and open person. So I'm really looking forward to this conversation. So for now, Melissa, hello. Thank you so much for joining us and welcome to the BLC Box.
Well, thank you for having me here today.
Let me begin by saying I've seen quite a lot of discussion. And it refers on the one hand to the right to privacy and on the other hand to the right of data protection. Now, are these the same thing? Are these two ways of saying the same thing, or are they two separate things entirely?
To some extent, yes, they are the same. There is certainly overlap. As our daily lives become more and more datafied, there is an encroachment on the use of data that affects our private lives. However, what I think is important to understand about data protection is that it isn't just about the data itself, but about how the use of the data affects us. Data protection is actually about the protection of fundamental rights that are affected by the use of our personal data. One of those rights being the right to privacy, but it also protects a myriad of other rights found in the Charter of Fundamental Rights of the European Union. So where, for example, personal data is being used to make an evaluation, which then has a discriminatory effect, then that use can be challenged under data protection law. And there's the overlap between privacy, but actually it's about the right not to be discriminated against. So data protection goes beyond privacy, even though there is clearly an overlap.
Okay, and where does the right to be forgotten fit into this? What is the right to be forgotten?
The right to be forgotten is a concept that was established by the Court of Justice of the European Union in a ruling in 2014, and that was then incorporated into the GDPR. It actually wasn't an entirely new concept. It had been considered in some European countries before, and it was included in the proposal for the GDPR in 2012. But the ruling, nevertheless, did cause, quite a few ripples in the privacy sector. The right to be forgotten, in fact, encompasses three rights over personal data: the right to erasure, the right to object to the use of personal data, and where the personal data is being indexed in some way, the right to have it delisted. And it supports the outcome that should ensue when one of the data protection principles are being breached. Now, I won't go through all the principles, but I will mention an important one, which is purpose limitation. This is a requirement that personal data is collected for a specified, explicit, and legitimate purpose. Where the data is being used in a way that goes beyond the initial purpose that it was collected for, then it should no longer be used in that way and should be deleted. Even for someone who doesn't know anything about data protection, this makes sense. If you give your personal data to a company, or if you put your data on some online platform for a particular reason, a particular purpose, and that reason no longer exists because of the passage of time or because of a change in circumstances, then it is right that it should no longer be used. But because of the vast amount of personal data being collected, this is not happening. So the right to be forgotten is a way in which someone can question and make sure that their personal data is no longer used and is in fact deleted, where the original purpose no longer exists or is no longer relevant.
And in terms of identifying those purposes for which a company collects my data or a data processor, am I right in thinking that these are the tick boxes where many of them will appear at the end of a form, and I accept that you may use my data for the following reasons?
Yes, exactly. It may be that an organization is legitimately processing personal data that you yourself did not give it. And then it would have to do a legitimate interest assessment, and it would have to make sure that on its privacy notice that it clearly states, how, why, and for what reasons it's processing personal data. So yes, either you will have that tick box when you give your data, or organizations will have, usually on their websites, privacy policies, privacy notices explaining how they use people's personal data.
Okay. And in your experience, do people actually read this? Do us as consumers, are we tick happy so that we're accepting everything?
I think there's been quite a few studies that say they don't, and that's the difficulty. I mean, I always do, but because I'm a data privacy lawyer, and so obviously I would. I think people do not, and it's difficult for organisations because the GDPR requires you to give quite a bit of information to the people whose personal data you're processing, but also to give it in simple terms. And sometimes it's just very, very difficult to do that. And some organizations are able to do it pretty well in very short statements that maybe people will read. Others find it more difficult, perhaps because they're processing a lot of data in very complicated ways. I'm not sure that, as you say, I'm not sure that many people do, but at least if you suddenly do query, or you think, goodness, why is my data being used in this way? Or you find out from the effect of processing that there's something going on with your data that you didn't consent to, then at least you're able then to go to the organization's website and identify, how they're using it. Often, though, I would say that when people find that their data is being used in a certain way, they're not sure who is using the data in that way. They sort of see the effect, but they don't know where it's coming from, where it's happening. And that could be a really complicated scenario to advise someone on how to find out, where the source of the data is.
Exactly. That reminds me, I received a telephone call the other day where someone asked, is this Steve Terrett? Yes, it is. And then they launched into some sales marketing speech. And knowing that I was going to talk with you, I thought, I have privacy and data protection in mind. So I said, where did you get my telephone number from? And they wouldn't tell me. And it just struck me as very odd, because it's clearly I have given my telephone number somewhere, and I'm not sure in which forum I have given it. Do you just have to tell people to give up in those situations, or is there a way of tracing it back?
I sort of relish those calls. I take it as an opportunity, and the person on the other end usually hangs up, or you can tell they sort of out of their depth. No, I would say not give up, because I think people sort of say, oh well, the data's already out there, but data has utility for a certain period of time. Data isn't necessarily useful forever. And so if you sort of give up and say, well, whatever, then, it's a continual cycle. But if you stand your ground, and it's easier to now, it's easier, with the GDPR, with the ability to say, well, I'm just going to report you to the data supervisory authority, it's easier to challenge it. What's more difficult, I find direct marketing is an easier challenge in a way, because you have an automatic right to say no and have it deleted. What's more difficult is where your data is in sources that you just don't know where it is. Is it in a report somewhere? Is it on social media somewhere? Has it been put on social media, but you're not a user of that social media, so you don't know? That is really, really challenging.
And of course, in this Facebook world, maybe I've put my telephone number somewhere on Facebook, or a friend of mine has.
Data scraping, people, organizations that will scrape data off the internet.
Okay. So I like the imagery of scraping data. It's very, very nice language, scraping the data. So what exactly is the scope of this right then? How do I understand it to a layman like me? What are the boundaries?
So the right, as I said, was created by the CJU in the Google Spain ruling, and then it was incorporated into the GDPR in Article 17. And the right to be forgotten essentially has two aspects: delisting on the one hand and erasure on the other. Now, the Google Spain ruling was a delisting case. A man called Mario Costeja Gonzalez asked Google to delete a search result that came up against his name when it was typed into the Google search engine. He objected to an article about debt proceedings against him that dated back to 1998, which had since been resolved. Google refused, and he complained to his data protection authority. And the DPA agreed with him and challenged Google, and the case reached the CJEU. Google argued that it wasn't the controller in respect to that data. That data was in the control of the newspaper publisher. However, the court disagreed and found that because Google's search engine organizes and decides how data appears in its results, it is in control of the data. And what the court found to be important was that Google is able to significantly increase the exposure of a person well beyond that which individual website publishing information can do. The information was out of date and no longer accurate, breaching the data protection principles, and therefore had to be delinked from the search results against his name. Now, Google was not in control of the actual data being published on the newspaper website. It was in the control of its algorithm. So it couldn't ultimately remove the source, but could delist it. So the boundaries of the right, whether that be in relation to delisting or erasure, are not always clear, because you will often have competing rights to the use of the data. The right to data protection, as found in Article 8 of the Charter, does not take precedence over other Charter rights, remembering that those rights are particularly wide in the Charter. So you have Article 16, the freedom to conduct a business, Article 23, equality between men and women, Article 10, freedom of thought, conscience and religion, and of course, Article 11, freedom of expression and information. And this tension between the rights can be particularly acute in delisting requests. Whilst you have the right to control over your personal data and your right to privacy, this must be balanced against another person's right to be informed or receive data, and against the right to freedom of expression of the source publishing the data. So to come back to your question on boundaries or sort of parameters, in many circumstances, this will come down to a balancing exercise of competing rights. Where that balance lies is not always clear, and of course will change over time to take into account changes in society's cultural norms, its attitudes, and approaches to the exercise of these rights.
And is there an element of should we say, rewriting history here? That am I entitled to search the internet, find things about me that I don't like or that I don't wish the public to know, and in a sense, airbrush the past?
It's a difficult concept because on the one hand, you want to give people control over their personal data that is meaningful. And on the other hand, you don't want to present imbalanced information to the public or impede the press in their important role in democracy. But there are some serious consequences for individuals for certain types of information being available online. So the US case of Ashley Payne is often cited as an example. She was a US school teacher forced to resign because of photos on her Facebook page showing her drinking alcohol with a caption that included an expletive. And the school said that's not in keeping with your profession, and she had to resign. Another US example is the case of Amanda Todd, who suffered relentless bullying as a result of the posting of an intimate photograph online that eventually led to her suicide. There are other valid reasons on a lesser scale that still have significant personal consequences for people. I can't discuss my own clients, but Google, on its transparency report, highlights examples of applications it has agreed to. For example, to delist postings criticizing a person's professional competence, despite there never being any investigation or finding of malpractice. The delisting of family members' names, linking them to another family member who had committed a murder. There was no question of them having any involvement. The delisting of articles alleging sexual abuse where the person had been acquitted. The delisting of nude professional photographs where the person had changed professions. So yes, whilst we say that, well, it might be editing our past or changing what's available in a way that perhaps is not truthful, on the other hand, should these people suffer from the actions of others or for changing their lives or for wanting to shield themselves or their family members from things they have done in the past? And the balance between the right to privacy against the right to freedom of expression is a difficult and often nuanced one. And I would say that part of the assessment in delisting information by search engines, Google's the biggest, does include this consideration of information that needs to be publicly available because it's in the public interest. So that is part of the calculation to balance it so that, as you say, it's not a rewriting of history.
And now you mentioned public interest and transparency there, and this reminded me that one of our students sent a question, and the question, I think, touches on some of those things that you've mentioned there. It was an example from Romania, and apparently in Romania, then when lawyers do their professional exam, they have a choice about whether, following the exam's results, whether their score is available publicly. And if they don't want it to be available to the general public, then they can anonymize their results by sitting the exam with a code number rather than with their name. And that option seems to be not available to the judiciary, those who want to train to become a judge. And the question said, well, can you explain the difference? Is it because there's private sector versus public sector? What factors would you identify in that scenario as being the distinguishing element?
It's predominantly about faith in public institutions. Transparency is needed so that we can see how decisions are made in the public sector that will then affect our lives. And having faith in public institutions is very important for democracy. And so there will be circumstances, definitely in particular in the public sector, where after all, it's taxpayers who are paying for those services, that there is this transparency so that we can see how decisions are made, so that we can have faith in our institutions. So it's largely because of the public interest.
Mm-hmm. Okay, that makes sense. Now, if again, if I identify something that is related to me, or perhaps I identify something related to my company, and I think that this, I would like this to be removed. I suppose there are two questions that I'd like to ask. Firstly, is there any real distinction between whether it is a person in the sense of a natural person, a human being, or a corporate person? And secondly, what is the mechanism for then beginning the procedure to have some data removed?
Okay, so the GDPR protects the rights of natural data subjects, so a human rather than a legal corporate. So it would have to be a person who's trying to exercise their rights. Now, it might be that the company is affected by the processing of personal data of an individual. And the remedies take that into account, but it still can only be exercised by the data subject. So there's a difference between delisting and erasure. So delisting applies where the organization is making the information public or indexing it in some way, but cannot delete the actual data. But that usually people go down that route where it's actually the problem is being caused by it being available on Google. It's, the fact that it's somewhere else isn't the real problem. The real problem is that people can find it very easily under your name. And so in that circumstance, or perhaps it's, a site that indexes rather than, or takes indexes from all over the internet, and it happens to have this information there, which is causing the problem. So that would be a delisting request. And often the larger organizations, Google, Amazon, YouTube, they will have their own procedures. You just go onto their website and there will be their sort of delisting form, and you fill it in. And then that goes off and they make their decision. An erasure request is different and actually a bit more difficult depending on the organization. Some organizations, it's very easy to access information, and you can they have maybe a whole team that deals with data subject access requests, and you would use it as a data subject access request. You would follow the same method. Now, I would say that it is slightly more complicated when it comes to the right to erasure, because you may not actually know which information is causing the problem. So often what an individual would do is to make a data subject access request, just start off asking, what information do you have on me and what information are you processing on me, before saying, I want you to delete it. Because another issue that can arise is that if that isn't the source of the problem and they delete it, you might be getting rid of a service that you really rely on and you use all the time, and it might not even be the source. So, organizations may be processing data in one way that's causing a problem, but not in another. Perhaps in the second way they process it, you really need that. If you were going to write to Apple and say, I want you to de-link me from my ID number, you would have no access to any of the services that they provide you for everything else. So you have to think carefully about what exactly is it that's the problem. Some people might just be purists and just want to be deleted, go off grid, and that's fine. But for everyone else who actually wants to use certain services, so usually you'd make a data subject access request. Now you have to have a legal basis, which is under Article 17.1, to be able to make the request, but it's very wide, and it covers pretty much everything. The first is where you think the processing is no longer necessary for the purpose for which it was originally collected. We talked about purpose limitations. So you're basically saying, I don't know why you've still got this, you don't need it anymore. The second is where you withdraw consent. You originally consented and you gave the organization your data. The third is a bit more complicated. You can object under Article 21 of the GDPR. And this is where consent isn't the legal basis. So you've got, they're processing it under a different legal ground. There is an automatic right to objection to direct marketing. But for the other grounds, there is a balancing exercise between the legitimacy of the processing for the organization against the person's particular circumstances and you hear this, it goes run throughout the GDPR, their interests, rights and freedoms. And there you would look at what is the legitimate interest that forms the reason the company, the organization is processing the data, and what is the reasons, what is the effect that that's having on the person, and where's the balance lie? Actually we should stop processing this data because it's having this significant effect on this person. To be fair, the fact that they've objected, unless you really feel strongly about it as an organization, I would advise just delete it. Why would you engage in a fight with someone who really doesn't want you to process their personal data? But there may be reasons that companies wish to challenge that. The fourth ground is where the personal data is being unlawfully processed. And this relates to Article 6 of the GDPR, which sets out the 6 bases for processing data. So consent, contract, legitimate interest, and so forth. And you would basically be saying, oh, I don't think I gave you consent. Looking at it, you think I gave you consent, or, well, the contract said this, but actually, if you really look at the contract, you're doing it for all other sorts of reasons or whatever. So you would then challenge it on the basis that actually the legal basis isn't valid. The fifth reason is if there is a legal requirement to delete the data. Perhaps legislation is introduced that says, all, I don't know, social media data collected between XY has to be deleted for XY reasons. There aren't many legal requirements to delete data, but I did write an article. If you go to my blog, there's a link on it there, about sunset clauses and deletion of in relation to COVID data specifically. So if people are interested in sort of, mandatory reasons to delete data. And then the sixth ground, which I find really interesting and I think is really important, is where the personal data was collected in relation to the offer of what they call information society services when you were a child. So children have been given special protection by the GDPR, recognizing that they may be less aware of the risks and consequences in the use of their data. So the sixth ground allows a child or adult who provide the data when they were a child to apply to the website, the social media, the platform, whatever, information society services, the definition is pretty wide, so any online platform really, to have the data deleted. And the organization can then object either on the basis that none of those grounds are met, or if one is fulfilled, there are further exemptions, which are in Article 17, subsection 3, and I won't go through them all, but I will go through two of the most relevant, which are the first, which is for the exercising the right of freedom of expression and information, and the last, which is the establishment, exercise, or defense of legal claims. Where a company can't delete the data because they might be sued, and so they need to have the data to defend themselves. So that's the basic way you would go through. You would look at, does the company have its own way of dealing with it? You look on their website. If they don't, you'd have to write a letter. Again, usually making a subject access request first, and then if you then wanted to delete the data, you can do it all at the same time, but it's probably a two-stage process. And then you would just go through and say, once you have the data and you know why they're processing it, it's easier then to work out which legal ground or which ground you're actually relying on. It might be obvious if it's data you gave as a child, straightforward, you go straight to ground 6. But until you know what process is giving that effect that's causing the problem, it's then very difficult to know which ground you're arguing.
And how would that work then in relation to multinational companies or servers or services, so that perhaps the same data is being stored in multiple locations? Does one application automatically remove it from everywhere, or does it involve separate applications?
That's probably a two-part question. I deal with the first part. I'll deal with the more complex part of that answer. Starting with, if any of your students there who are studying, about data protection, they will know all about those. But it still surprises some. The GDPR has extraterritorial reach. And so it applies when the factors in Article 3 are met. So where you are a company that is established in Europe, even if the processing takes place outside of Europe and irrespective of the nationality of those data subjects, then the GDPR applies. So if you have a data subject who is exercising the right to be forgotten here, the GDPR applies to you. It doesn't matter where the data is. You have to follow that request. And in fact, you actually also have to inform other data controllers with whom you share the data of this request, and they have to delete the data as well. So you might receive something from a company that says, we've received this request, we've deleted the data, and then you have to go through that process again, because your processing might be on different legal grounds that might be valid. So, but generally, once it's deleted at source, especially if they were the original company that collected the data and they've given it to you, it's a pretty tricky argument to then say, oh, well, we're going to keep processing it when that consent and that original collection has been in effect deleted. The second scenario is where you are a company established outside of Europe, but you are offering goods and services to data subjects in Europe or monitoring the behavior of data subjects in Europe. Then the GDPR applies to that processing. So in those two scenarios, that is where the GDPR does apply to you, whatever company you are, and you have to comply with a valid request for the data to be deleted. Now, there may be requirements, as you say, in various countries for companies to keep the data for the purposes of the law in that country. Then it could argue it has compelling legitimate grounds that override the data subject's right to have that data deleted. However, there is a difference between processing the data for one purpose and keeping a record of it for another. So it may be that the company has to stop processing the data for the purpose that the person objects to, but may keep the data, just a record of it, for the purpose of satisfying local requirements. So this particular conflict hasn't been tested in the courts in relation to the right to be forgotten. But I would say that the recent case of Schrems 2 in the CJEU is relevant. I don't know if you've heard anything about Schrems 2, but in privacy circles, it's a big deal. And the court looked at the validity of transfers of personal data from Europe to the US. It found that because the US government security agencies have access to personal data that cannot be legally challenged by European data subjects, that such transfers are unlawful unless supplementary measures are instigated that guarantee the right to data protection guaranteed by the Charter. So if the CJEU were to examine a company's legal obligation outside of Europe to keep personal data, it would scrutinize those laws to make sure it is consistent with the principles of the Charter. And if storing data in those countries means that data subjects can't exercise their right to be forgotten, then it may be found that the data should not be kept there at all, and it was an unlawful transfer of data to begin with. So that's sort of how I would answer it. I think there was two parts to that, wasn't there? You said...
Well, I was inquiring whether it would involve multiple applications for the erasure to take place, or delisting.
Yes, I mean, this is the tricky thing. So you've got the organization that you know is processing your personal data, and you make this request. And they then are obliged to inform other controllers about the request. If they are unable to, for whatever reason, they have to sort of give you an indication of who they've shared your data with. And then you would have to go through the rather laborious exercise of going through it with each controller, which is why often people go with delisting, because you just go to Google, or, and then you just delist. And then once you've delisted, that information is still available. I mean, Google will inform the webmaster that it has delisted the URL. But you, if you wanted to have it deleted, so you would delist, and then you would have to approach the webmaster, and you'd have to make an application for erasure as well. So it just depends sort of how far you want to go, because it could pop up again, or the information could be anywhere. And as they say, with the sort of crawling of the internet and these algorithms that go and pick up information everywhere, you don't know, it just could come back. You've delisted it, and then it just comes back. And when you delist against your name, but it doesn't mean that the different search terms won't bring it back up. So if you Google Melissa Stock, maybe I've delisted against my name, but if you put, I don't know, barrister, privacy law, UK, whatever, I'll come up again. It'll cut that, that top search result will come up. So it's a solution to some extent, but it doesn't finish it off. You may still have to then go and make all these other requests.
And are you legally entitled to, should we say, cast your net wider and come up with a list of, rather than just your name, but to come up with privacy, barrister, London, etc., and throw net as wide as...
Unless you can ask. I mean, if you're delisting, unless your name appears in the URL, that's not what will happen. I mean, what some people do, and this, if you look at the case of, again, this is on my blog, so I won't go into it in detail, but if you look at the case in the UK, which is in the High Court of NT1 and NT2, these were two individuals who wanted links to articles discussing their previous criminal convictions delisted. And one of them had, I think, both. One of them in particular had engaged the services of a company that would then put out good things about you to sort of move you down, and sort of try to change the sort of interpretation of the results. And he was criticised for that by the court, because it said that he was trying to paint a picture that wasn't truthful, and that it was in the public interest that that there was a truthful picture of what had happened. So I would definitely advise against, thinking, okay, well, the solution is just to flood Google with, good things about me. You can do, it depends very much fact specific. It's very about the context. If you're putting things out there that are sort of unrelated to what was delisted, which are good about you, that's fine. But if if you were sort of defrauding people in your position as an accountant, and you were still an accountant, then the court will say, no, 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 you know, that's still your profession and people need to know. But if you're then, you know, a florist and you're writing about how good your bouquets are, then the court's not going to have a problem, you know, won't have a problem with it. So it depends on the context, but it's something to be mindful of. I would read NT1 and NT2, the case, if not I have a summary, but it's quite interesting how that's addressed by the court.
And were Google's initial attempts to fight this in the Google Spain case, were they due to a question of principle, or is it just about the money, that it's going to take them more people and more time to be dealing with these delisting?
It was both. You know, I think it was both, to be fair, on Google. I think I think it's, now we're used to it, but I think it's quite alarming to think, I'm going to have to police this. You know, we are going to have to say, oh yes, you can have this on the internet. No, you can't have this on the internet. You know, it was quite a big deal. They were saying, well, you know, the argument was, well, we're not best suited for this sort of exercise, this balancing exercise between Article 8 and Article 10 of the Convention, or, you know, 7 and 11 of the Charter. You know, this is not a business decision that companies make often. They don't often think about. And this is actually the difficulty in data protection, is that, you know, a legitimate interest assessment or a DPIA involves this assessment. And it's not it's a difficult assessment. It doesn't come naturally. It's not something that most businesses are prepared for. You don't go to business school thinking about fundamental rights, you know. It's not something that's top on the list of your modules. So, you know, then you have to make these decisions and you have to make these assessments. And often it comes to the courts and they'll say, you didn't engage in your assessment. You didn't engage enough with Article 8. And I do have some sympathy for companies, you know. If you're relying on legitimate interest as a basis of your processing, it's important that you really engage with that balancing exercise.
It was, of course, I'm sure you will have heard the apocryphal stories about at school whether you're allowed to sing at the end of their happy birthday to you. Can we say children's names anymore, because this will be a breach of their right to privacy? But even within the British Law Centre, there are, when it comes down to the more nuanced questions, it can get rather tough, because when students register, of course, they give us information about themselves. It could be name, yes, date of birth, where they work, are they a student? And some of that, I can imagine, we don't really need that in X number of years' time. But exam results, you would like to think we can keep, because if someone asks us for a reference, we would look a bit silly, yes, if we say, sorry, but we deleted all of your results. So how do we find the right balance? Is it trial and error? Or avoid trial by not making any errors?
I mean, I think it's difficult because, as I said, for example, if you had a request to delete the ID from which you were identified at university, and then you delete that, but you know your IT system then deletes everything related to it, including all of the results. And then they call you up and say, oh, can I have my, proof of my result from, and you're like, we deleted it because you told us to delete your ID number. And then they'll say, but no, I didn't mean delete, my results. So it is difficult to know how far to go with it and what to keep and what to delete. But I think that, if you can pseudonymize, identify the data, you must. If you can separate it, and if you can really just collect as little information that you really need at the very beginning, that is the ideal situation to be in. It's very difficult where obviously you're in situations. I mean, I find in my work, sometimes people tell me things that I think is just not relevant. I'll say, don't send me everything about your personal life. I only need this amount of information to advise you. I don't need everything. Please don't send me everything. Because you don't want, the responsibility of any personal data that you really don't need to look at all. And I think for companies as well, I think it's about just stripping down, but of course it's difficult because organizations also can use that data for very many things and to interpret and to work out what parts of their business are successful, what products people really want to use, and so they don't want to give up data that can help them do that. So it's tricky.
And of course we're still going through the COVID crisis, and some of the government's responses in most countries have involved some kind of element of track and tracing. There's been lots of apps, and that could involve questions such as, where do you live? Who do you live with? Who is in your bubble? Is this a question where the government can simply press a big red button and say, look, there's a pandemic on, there are health threats, let's put GDPR and privacy and data protection to one side for the moment, and we'll talk about it later? Or do they still have to balance these factors up in their response?
They can actually do. I mean, there is in the GDPR, you can process data in the public interest for for health reasons. And so the pandemic, there isn't anything in GDPR that stops them collecting health data in that way. Of course, the difficulty is now you're collecting all other sorts of data, not just health data, but as you say, location data, other personal data, your address, your email, and so forth. I mean, they still have to comply with data protection rules. And it is perfectly possible to comply with data protection and be able to achieve these things. One thing I would say, and actually, I mean, I wrote a blog about it, and I think we all, we've really focused on the sort of what will happen to the data later. Will we be used to discriminate against certain people? Will that data be passed on to other government departments that make decisions about people, and they don't know, what decisions are being made about them on the basis of that data? But interestingly, some of the biggest problems so far with track and trace have not necessarily been, there've been some data. I would be most concerned about data breach, that you give all this data and then there's a big data breach and then it's stolen and it gets out there and you have no control over it. But actually, some of the bigger problems from a privacy point of view have been on the ground. So it's been things like people phoning up restaurants, pretending to be people and saying, I'm from track and trace. Can you give me the email addresses of the people that, have been in? So, and then calling up those people to harass them or to stalk them or whatever. And I know these are real, these are not my clients, by the way, but this is other personal examples that people I've heard of, anecdotally. So we will worry about, the cybersecurity and all that. And actually, it was the very simple on the ground pen and paper method that was that actually ended up being quite a problem. And I suppose with the downloading of the app, there's less people sort of writing down some poor person who works in a cafe being phoned up, and under that sort of stressful, I've got to save these people's lives, I better give them all their information. So yeah, it's difficult. It's difficult to know. No, the government can't do everything it wants with the data. It has to follow the rules, but it's the sort of how they're going to use it later, where it's going to go, where it's going to end up, and data breach that is the most concern, I would say.
Okay. Now, I think we should congratulate ourselves that we've been talking for a while and not mentioned the terrible B word. But I feel that having raised the Schrems case and the idea of transferring data to a non-EU country, and all of our discussion being about the GDPR as an EU piece of legislation, it's only a matter of time before we have to say, what impact does Brexit have on all of this?
So Brexit has not changed anything substantial. The UK has incorporated the GDPR into its law largely intact. And the UK is waiting for a decision by the European Commission on its application for adequacy, which apparently is going to be imminent, as in within the week, perhaps even. And this is a decision that would mean that UK data laws are found to be essentially equivalent to EU law. That is, it offers the same amount of protection so that data can flow freely from the EU to the UK. And this is an important decision for the UK because it would be much less costly for businesses and would provide frictionless flows of data. It would carry on as before, essentially. So if the UK were to try to dilute data rights by, say, removing the right to be forgotten or adapting it in a way that was at odds with the EU's approach, then it would jeopardize any adequacy decision given by the European Commission. So the short answer is no. I don't see that the UK government would do that. And so it hasn't affected the right to be forgotten. There's more technical problems with it in the sense that you'd have to, if you wanted to go to court, you now would have to go and apply to serve outside the jurisdiction and things like that. So there's sort of those sorts of things, procedural sort of problems that have been arisen, but the right itself has not been affected, the exercise of it.
Okay. And as the Commission is debating now and talking increasingly frequently about the Digital Services Act and the Digital Market Act, will they impact on this area of law at all? And If so, are there any indications whether the UK plans to keep pace with those developments that are happening at an EU level, or rather to go its own way, as it were?
So the European Commission has proposed reform to the digital market, you say, through the introduction of the Digital Services Act and the Digital Markets Act. And both will be regulations and will therefore have direct effect in the European Union. The Digital Services Act will implement new rules for internet services providers, cloud services, online marketplaces, digital sector, all those sorts of platforms and networks. And it will place greater responsibility on them to provide notice and takedown mechanisms, to remove illegal content more quickly, to establish mechanisms to deal with disputes and repeat infringements. Now, this does interact with the right to be forgotten in that it supplements it by placing greater responsibility on platforms to remove content. However, whilst the Digital Services Act is aimed at removing illegal content, breaches of copyright or things that are defamatory or a form of harassment, the right to be forgotten applies to legitimate information that for whatever reason should no longer be processed. So they tackle different problems, both involving the same forums. And the Digital Markets Act is more about competition and dominance of the large technology companies, and will prevent them from using unfair practices, a preferential ranking of products and services, imposing exclusivity provisions. So you have those sort of two angles to it. What the UK would do, it's hard to say, but I would like to think that the UK wouldn't want to diverge too greatly from the European Union. Again, we have, in terms of personal data, we have adequacy. And the fact is that we all face the same challenges. There's no denying that the technology companies are US based. We're facing the same problem in Europe and in the UK when it comes to the dominance of those platforms. Some people would say the dominance is a good thing. They have economies of scale. They have a track record of creating incredible products. They attract the best talent. They have the most resources. They have the best research and development. Why would we want to break them up or introduce competition to the point where you actually can't get these products out as quickly as someone like Google can or Amazon? The other side of that is saying, well, it's not good for the consumer, and should we have these organizations be in control of so much data? So I think it's a common problem, common challenges for Europe and the UK, and I would hope that we would move in tandem on that.
Okay. And in your opinion, what do you think are looking forwards to the future, the next 5 years, 10 years, what do you think are the most likely developments or the most interesting debates that are going to arise in the area of the right to privacy, data protection, right to be forgotten, the macro level discussion?
Yeah, I think the data landscape in general is becoming more and more complicated. I know we hear this a lot, and probably everyone is a bit fatigued by the data gloom and doom. But it isn't simply that we are all slaves to social media or that we are being tracked in every aspect of our life. How we are evolving as a society in our use of technology, in particular in this pandemic, which has sped up the adoption of technology, will shape how our regulations develop to tackle the inevitable problems that arise from engagement with new technologies. But governments face difficulties in finding the balance between encouraging technological innovation by businesses that benefit society, but also preserving control over personal data and privacy. And companies, will face legal uncertainty to some extent in relation to how governments decide to legislate. And I think it is a societal question. How far can we develop artificial intelligence and these new technologies without the use of massive amounts of personal data? Is it right? Is it wrong? These are technologies that could vastly benefit society. It could allocate resources where we can see, resources need to be allocated. It can promote productivity. It can promote efficiency. It might not. I'm technology neutral. I'm not saying it'll cure all ills or that, it's terrible. But, how far it's a societal question to an extent. I think it needs a lot more debate. The problem is, of course, is that you don't know which technologies will be adopted and will be the most useful. So, the Google glasses, I don't remember the years ago, everyone's been wearing these glasses, all of us. No one is. But other things that you just didn't think would be, Zoom, who thought Zoom would, come into its own like this during a pandemic, so the problem is that you then thinking about technology, you don't quite know which ones will be adopted, how they'll be used, but they are happening. They are being developed. The IoT, all the products we use, facial recognition technology, it's happening. And I think as a society, we need to discuss really, are we for it or not? And can we realistically say that you can protect personal data when you need the personal data to train these models? I mean, I think that if people had known what it took to develop Siri and to develop Alexa, they probably would have said no. If they said, well, we're going to listen to every conversation you have, and then we're going to train it, we're going to put all those conversations, we have real people listening, human beings listening, not computers to start with, because they needed it. We're going to train our systems tons of your, personal, not just your personal data, your personal conversations, to create this brilliant product. People probably would have said no. I mean, now it's all done. They don't really need the human beings now. The technology, the data comes into the computer itself. So, your personal information is sort of happening, and everyone's okay with it now. But it wouldn't have happened if people hadn't agreed to their person. So that's the difficulty, I think. And I'm not sure there's a legal answer to that. But it's definitely something that society needs to think about, because we can't move forward in technological terms, I think, unless we can have access to personal data. And then it's, how far can we go, and what are people comfortable and not comfortable with?
I'm not sure whether this is a true story or apocryphal, but I read something about a couple who had installed, is it Siri or Alexa, into the light bulbs, or there was a connection where you could basically have a presence via the light bulbs. And whilst discussing with each other about another couple who were their friends, it recorded the conversation and then sent it by email to the other couple, and apparently contained some elements of the conversation that were none too flattering, shall we say, to the other couple. And George Orwell would have found this very strange, because the idea of us being spied upon by some external force seems now to have been reversed, whereas we are the ones who are telling the world about what we had for breakfast and who we spend our days with and screwing it. So is there a conflict that, on the one hand, the world has never been so interconnected and spreading as much information about itself in general, including personal lives, whilst on the other hand, we are trying to protect data protection more than ever? Or does one cause the other?
I don't know. I think I agree with them. I think, yes, we're being spied on, but we're doing it to ourselves.
Yeah, absolutely.
Orwell was not about, it was about the state spying on you. We're sort of letting the private sector spy on us to deliver goods, but they don't always tally. So, when you have Alexa, you use Alexa, that's what it's doing, and that's how you're getting the result. I use Alexa, I'm using Alexa to put on my favorite radio channel because I don't want to go over there and have to press a button, But and so I think, but the problem is when you are giving information, you don't know what it's being used for to the private sector. So and that's the whole ad tech and the tracking and everything else, that you think you're giving your data for one reason, and actually it turns out, democracy is being challenged. Well, all I did was say that my car I drive is a Prius. And that's the problem with it. Is not so much where the outcome, the effect of what personal data you're willing to give up, but when you're giving up personal data and it's having a completely different effect that you were not on board with, and that is a challenge. And I agree, but would we give it up? Would we not want to press a button and have Uber outside our door? Would we not want to have our food? It's easy to say, well, I want out, and I don't want to be tracked at all, and I don't. But then I think, is that realistic? And then then you complain about, well, it's also difficult when I can't have this convenience. I don't know what the answer is. Absolutely. But I think there has to be a sort of education, perhaps. Maybe it's more a question of people knowing that this is what's happening, and that's fine. If they want to give up their privacy for a price, that's fine, but they have to know that that's what they're doing. And there has to be some way of protecting, democratic institutions or democratic principles. It can't be that something like Cambridge Analytica can happen, just because somebody wants to access the internet for free or wants to play a quiz, because it fills their time for 5 minutes. But there has to be, I think, transparency, really.
And then looking at it rather than from the perspective of either at a meta level or from the individual level, from a company's perspective, we all know that information equals power, and that there are so many more tools now to gather information about customers or people who clicked on our adverts, and that can be used in a good way to help our customers. I mean, it could be used in a less good way to harass people. Clients very often now talk about, should we say, auditing their data processing procedures within their company. What should companies just generally keep in mind when they're assessing their data processing procedures? And are there any common mistakes that you could say, try not to do that?
Yes, I mean, I would say that, as you say, organizations will conduct their audits to work out, to track their data flows. Where's the data coming from? What's it being used for? Where is it stored? Is it being shared? And so forth. But I would say that a common mistake when documenting how personal data is being used on what legal basis under the GDPR, a common mistake is to do it the other way around and say, okay, we are using the basis of contract because we have a contract in place with the data subject, and that covers all our data use. It often doesn't. You may have a contract with the data subject that covers some of the data processing that flows from it, but other data processes are probably more likely to fall under a different legal ground in Article 6. So work out the data processes first before they happen, I might add, although I know it's a bit difficult with the introduction of GDPR, it sort of had to happen backwards, and then work out the legal ground is suitable, and really think very carefully about those data processes. Don't just say, oh, we have a contract. Oh, okay, good. The legal basis is a contract. We can now relax. Because, you might have a contract to, as a retailer, you get that person's address and you would process that address to deliver the goods to the person, perhaps. But also you would have that address to be able to make the payment, and actually those two come together under contract. But then you might use it for sending them leaflets under the direct marketing. So, you will have different processes for using the same piece of personal data. And make sure you've really thought about that. Don't miss any. It's easy to miss one out. Make sure you're aligning the legal process to the processing, and not sort of saying, oh, we have a contract and then let's just stick it all under that, is what I would say. And also privacy policies and privacy notices. Now, there was a big rush, obviously, to just get them out there. And you will see privacy notices that contain all the right words and phrases. We process your data under the following grounds, we don't share your data, and so forth. But when you scratch under the surface of it, often organizations don't really know which process is covered by which ground. And so, they've rushed to put this out there. So, okay, we use legitimate interest, we use this, we use that. And I say, well, look, what does your business do? Look at what your business processes are. Before you sort of just put out a notice, you have to step backwards. And people like to say, oh, could you look at my privacy notice and see, okay. I said, well, I don't know. You have to tell me about your business first. I can have all the right words. I'm sure it's all perfect. But unless I know whether it actually matches what you do, I can't tell you whether or not it's actually valid. And the third thing I would say for organizations is don't wait for the problems. Think about how you're going to deal with data subject requests before they happen. You could be a joint controller. So in which case, who's the one who's going to deal within two organizations? Who's going to deal with data subject access requests? Who in your organization is going? If you're not a big organization, especially, who's going to deal with it? Because you have a bit of time with data subject access requests, but it can pass by pretty quickly. And also think very carefully: what are you going to do if you suffer from a data breach? You only have 72 hours to determine whether or not a data breach needs reporting to the data supervisory authority. So I would say make sure you have the technical support, or at least have identified one or two companies that can offer data breach IT services. So you have a plan for who you're going to call if you do suffer from a data breach. If you're not, huge organizations will have their own internal, but don't wait until it happens. and scramble around because you only have 72 hours. So, who are you going to call? So just make sure that in your mind, that you've done that research and put a plan in place for that.
The good news in that, I suppose, for our students is that it implies, if not demands, that legal advice is sought earlier on in the process. Let's get the lawyers involved in terms of designing these policies rather than just trying to defend them when something bad happens at the end of the story. But
yes,
that reminds, sorry.
It is. I mean, it's a shame. I think the problem is a lot of processes already exist, so people don't want to go back and spend the money on it. But yes, I mean, ideally, if you're creating a new product design process, a stream that creates different processing activities, then ideally you would, because you could just get it right from the beginning and save yourself a lot of time and money later on.
And that reminds me of a comment we received from one of our students from Poland, who said that they'd been speaking to a colleague who is involved in data protection law, and she had advised him, give it up. Don't focus on this area of the law because it's saturated and there are no real opportunities anymore for the market to grow any bigger. And Jakub said, could you ask Melissa what she thinks about that? Is that true?
From my point of view, I haven't, from what I've seen during the pandemic, that a lot of law firms, here in the UK, are still hiring data privacy, data associates. I haven't seen, in fact, I see a lot of demand for data associates. Here, at least here in the UK, amongst most private practice. And I think there is still a lot of demand. Also, I see in organisations looking for in-house, legal counsel and data protection officers and so forth. So I think there is still demand. I can't see there being less demand. Maybe it is saturated to an extent, but I can't see there being any less demand going forward, given the complexity of the way we use data. And not just, I think if you focus too much on data protection and privacy, then maybe you're becoming quite niche. What I do is quite niche. And there aren't a lot of privacy cases that reach the courts. There just aren't. So there'll be very few each year that and many settle or get dealt with earlier on in the process. But data, I think, an interesting area, and I think perhaps something that students should bear in mind is that it's not just about personal data. You have intellectual property, which involves data, the use of databases. Databases may be mixed with personal data and data, and that is an area where organizations need advice and need more advice. So I don't know if it's not growing. I know that in the sector generally in data, there is a massive demand for people with data knowledge, and maybe it's more on the technical end, data scientists, but of all sectors, I think probably this and maybe renewable, sustainable energy and energy. These are the two sectors that are just going to keep growing as parts of the economy. So usually with that, the demand for lawyers comes.
Absolutely, and the European Commission seems determined to make it a focus of its legislative agenda in the future. So I entirely agree. I think it will remain relevant for very, very many years to come, perhaps even more so than now. Well, Melissa, I'm conscious about taking up more of your time than I promised I would. I've enjoyed this enormously. So thank you so much for joining us. It's been really fascinating. And I'm really looking forward to reading your new book on the right to be forgotten. Now, I mentioned at the beginning that you'd kindly arranged something for us with your publisher. Could you maybe just tell us what it is that you've arranged?
Yes. Well, if anyone is interested in the book, there is a free chapter available, I think, the publisher's made. So if you look online, maybe that's the only chapter you want to read, but you can read that. Or I've arranged for a 15% discount for the British Law Centre, so until the end of the month. So if you're interested in buying the book, then I think, Steve, maybe you'll send the code to your students.
Definitely. It will appear when the video appears. It will be down there, or I'm not quite sure which direction to point it. It will be on the screen at the moment. And it is BLC 6715. And in the meantime, of course, we can keep on top of things directly from your blog, because it is incredibly up to date. And the podcasts on there are extremely accessible. And I think you have a great way.
Okay, well, thank you for that.
They're great entry points, and you're not afraid to deal with complicated points, and definitely can. But you also make it very accessible for people who are coming to the subject, not being an expert in it. So I think I highly recommend all of our students check out Melissa's blog, and of course follow that up with a bit of hardcore reading on the right to be forgotten. Well, Melissa, I can promise you that you won't be forgotten at the British Law Centre, and I hope that we'll be able to invite you back at some stage again for another BLC box. And in the meantime, the next time we meet, you will be sitting in the interview seat, and I shall be listening to one of your podcasts. So thank you very much for joining us.
No, thank you for having me.
It's been a pleasure. Goodbye.
Bye.